Hi, I'm Anna Peterson, and today I'm going to be talking to you about the process of a criminal case. According to the Utah courts, government's process goes as follows. First comes the right to counsel. The U.S. and the Utah constitutions guarantee that every criminal defendant has the right to counsel in criminal procedures. Just as stated from the Constitution anointed the Sixth Amendment right to have assistance of a counsel for his or her defense. In this case, the defendant cannot afford an attorney. The courts will provide one for them if the charges include jail time. If a defendant's income is less than 150% of the property lines, this establishes that the government disqualifies them for government help for an attorney. After this comes the first appearance. This is where a defendant is formally notified of the charges against them and advised of their right by a magistrate or a judge. A date is then set for a preliminary hearing for felony cases only. At this point, the defendant can waive this, but if they don't, then no plea is stated at this stage in the case of felonies. Then it goes to a preliminary hearing. Preliminary hearings are for felony cases and Class A misdemeanors, and their purpose is to determine if there is probable cause that exists, and to show if the defendant was actually the person who committed the crime. If the judge finds that there's probable cause, the defendant is then set for trial. If the judge finds that there is insufficient evidence, then the case is dismissed and charges may be amended at that point. Next comes the arraignment. The defendant is offered the opportunity to consult with an attorney. When the defendant is ready to go forward, the judge reads the charges and the defendant enters a plea. If the plea is guilty, the court will make sure that the defendant understands their rights and what they are waiving. And once the court knows that they totally understand the consequences of waiving those rights, the court accepts the plea and schedules a date for sentencing. If the plea is not guilty, a pre-conference and trial dates are scheduled. There are two different kinds of pleas. There's a no contest. There is also a no contest plea, which is the same procedure as a guilty plea, and the prosecutor will likely prevail to a trial. A judge can reject this kind of plea. There is also an Alford plea, which is when the defendant wants to use the plea bargaining and cannot or will not admit the guilt. This is to avoid potential consequences of going to trial without admitting guilt, and a judge also can reject this. Next is the pretrial motions. Before a trial starts, prosecutor and defense file a number of motions with the court for judgments to be issued, for the judge to issue orders, such as evidence of prior conviction, not to be in place, motion to suppress evidence or request for discovery, and these motions have to be written out and handed in 7 days before trial. Then comes the pretrial conference. This may be used to an attempt for a negotiation settlement of a case between the defense attorney and the prosecuting attorney. A judge also can reject this settlement. Next comes the plea bargaining. This is when negotiation between a prosecutor and a defense attorney make mutual decisions about the case. The judge isn't involved in this, but he has to approve it and all the arrangements that they have agreed upon. If everything is agreed upon and the plea of guilty is then entered, and then the defendant goes to sentencing. The next is the trial procedure. Depending upon the case, it can be tried by a judge before a jury, or before a jury and judge. The jury selection is next, and prospective jurors sometimes are asked questions to determine if there is any biases or 3 justices called. This is called voir dire, which in our book of Hall states on page 573 is a French phrase which means to speak the truth. If the judge feels the jury is not qualified, he can excuse them, and that is for cause, is what it's called when he excuses them. First comes the opening statements. Begin the trial with the attorney on each side, inform the court and the jurors of the nature of the case. Evidences then will, what evidence they'll have, they'll present, and the facts that they expect to prove. Prosecution, each side then makes its case using testimony and physical evidence. First the prosecuting attorney and then the defense attorney. The testimony from the witnesses has direct and cross-examination from each attorney. This is also where physical evidence, documents, and pictures and other exhibits are introduced into the court case. Then there is a rebuttal. After the defense is done, the prosecuting attorney can call witnesses to rebut any new information that the defense attorney gave at court. And the judge can allow also for the defense to come back and do a rebuttal. That was a tongue twister. Next comes the jury instructions. Jurors are given instructions by the judge before closing arguments as to the law they are to follow. In criminal cases, the defendant must be found guilty beyond a reasonable doubt in order to be convicted. Then comes the closing arguments, and this is where both of the attorneys summarize the evidence that they show, the testimony, and they try to persuade the judge or jury to favor their case. For the prosecution, then the defense, and then the prosecution can respond to the defense's closing argument also. Then there's the jury deliberations, where the jurors go to the jury room to deliberate and decide what it is that they believe to be true beyond a reasonable doubt. Then comes the verdict, and the jury comes back in to the courtroom, and in criminal cases, the verdict has to be unanimous. It is given in the courtroom and with the defendant present. He can waive the right to not be there, but most choose to be there. Then comes the sentencing and the judgment. If a guilty verdict, the defendant has the right to be sentenced in no less than 2 days and no more than 45 days. They can also waive this right and be sentenced the day of the conviction. Just as stated in our chapter 16 on page 583, sentencing and appeal that after a conviction of felonies and some misdemeanors, a future date is set, usually for sentencing. Thank you for listening, and I will have my references below my video I'm posting. Thank you.